Dear ladies and gentlemen, the previous presentations were extremely important, and we were able to learn a lot of it. I think the Hungarian constitutional traditions are going in the footsteps of the German constitutional theories in many respects. But as I'm going to demonstrate it this afternoon, the understanding of constitutional identity of the Hungarian Constitutional Court is somewhat different of the understanding of the German Constitutional Court. In this regard, my starting point, such as Professor Sven Simon has also mentioned, Article 4, Paragraph 2 of the Treaty on the European Union. From this, it is absolutely clear that the European Union shall respect the equality of the member states and also respect the national identities which are inherent in their fundamental structures, political and constitutional structures, including of regional and their local self-government legislation. In this regard, I think the starting point in the European legal thinking was the Solange I and Solange II decisions of the German Constitutional Court, which in a way, in a national institution, the German Constitutional Court tried to limit somewhat the application of those European legislation, secondary community legislation, which were regarded as being not in line with the basic and most important fundamental human rights regulations of the German Constitution. You know that in 1986, the Constitutional Court of Germany decided that it will no longer exercise its jurisdiction to decide on the applicability of secondary union legislations because it was entirely happy with the functioning of the European case law for the protection of human rights. So it is a weapon in the drawer, so to say, but nevertheless, it already had a significant influence when the fundamental law of Hungary was adopted with its Article E. In the fundamental law of Hungary, the Hungarian parliament prescribed that with a view to participating in the European Union as a member state, and on the basis of an international treaty, Hungary may, to the extent necessary to exercise the rights and fulfill the obligations deriving from the founding treaties, exercise some of its competencies arising from the fundamental treaty jointly with other member states through the institutions of the European Union. So the Hungarian concept from its origins was that the cooperation of the European member states is in harmony with others. It's not a subordination to an international structure. It's a harmonical cooperation of European member states working together. And in this regard, already Article E, in its original form, has contained two limitations for secondary European law legislations. One was the ultra-virus control. Everything that has not been adopted by the clear transfer of power from Hungary to the European Union, it is something which is not valid in respect to Hungary, at least in theory, at least in principle. The other limitation is that the most important human rights cornerstones of the Hungarian constitutions cannot be overridden by European legislation. That were these cornerstones. And then a very important and a very special situation had arisen in 2015, because on the 22nd of September 2015, a European Council decision was adopted, the 1601 decision of the Council, which adopted a quota system for the distribution and the settlement of asylum seekers in the European Union. And it is a very interesting thing that the Dublin system, for the at least prima facie, is contravening certain very significant provisions of the Geneva Convention, prescribing the most important international obligations regarding asylum seekers. As we know very well that, and let's disregard for a second about European Union law, the Geneva Convention is guaranteeing only one thing for an individual, that once it is in a third country seeking for asylum, it has the right that its petition should be read and decided upon by that country. Of course, in big federal states like in the United States, one member state can relocate its own citizen, can relocate the asylum seekers to the other member states, so that the decision should be decided upon there, because that's a federal structure. However, that very basic obligation of the Geneva Convention is rearranged somehow in another way, arising from the Dublin regulations of the European Union, and with the quota system, there is a very clear possibility that a group of people should be relocated from one member state of the European Union to the other member state. There is a prohibition of expulsion from Hungary in Article 14 that forbids this sort of action for the Hungarian authorities, and the Hungarian Ombudsman was asking the Hungarian Constitutional Court whether a group expulsion from another state to another European Union member state directing to Hungary would be in breach of the fundamental legal obligations arising from the fundamental law, as well as could be a breach of international legal obligations of Hungary. And what could be the potential outcome of the findings of the European regarding the European Union norms? A very interesting and a very significant decision has been reached by the Hungarian Constitutional Court. The Constitutional Court established that in course of exercising its competencies, it may examine upon a relevant motion whether the joint exercise of powers, with other words, implementing secondary EU norms, whether the implementation of these norms could be in breach of the sovereignty of Hungary or its identity based on the country's historical constitution. And very important key elements of the decision are that the Article E of the Hungarian fundamental law not only grants the validity of EU law in respect of Hungary, but at the same time, it imposes very significant limitations on the transferred and jointly exercised competencies. The Constitutional Court established two main limitations upon the joint exercising of the competencies. On the one hand, the joint exercising of a competence shall not violate Hungary's sovereignty. That is regarded to be the sovereignty control. And on the other hand, it shall not lead to the violation of the constitutional identity, and that is identity control. So sovereignty control and identity control is differentiated by the Hungarian Constitutional Court. What does the court mean by the one and by the other? Since by joining the European Union, Hungary has not surrendered its sovereignty, it's rather allowed for the joint exercising of certain competencies, and the maintenance of Hungary's sovereignty should be presumed when judging upon joint exercising of the competencies, additional to the rights and obligations providing in the founding treaties of the European Union. So, unless it can be proven to the contrary, the presumption of the Constitutional Court was that Hungary was on the side of maintaining its sovereign power in case of doubt, according to the findings of the Constitutional Court. The Constitutional Court also established that the constitutional identity of Hungary is a fundamental value. And this fundamental value was not created by the fundamental law. It was something which was only acknowledged by the fundamental law. So what is the origin of the constitutional identity? Constitutional identity is a historical development, and constitutional identity is only something that has been enshrined in the Constitution. It has been only expressed by the fundamental law. Therefore, no state power has the right to resign about Hungary's sovereignty. It cannot be deprived of its constitutional identity. And Hungary finally can only be deprived of its constitutional identity if Hungary's sovereignty would be finally terminated, and its statehood in its independent states would be entirely abolished. The constitutional identity of Hungary is actually not a list of static and closed values. Nevertheless, many of its important components, such identical with the constitutional values as they are generally accepted today, they can be highlighted by several examples, such as freedoms, the division of powers, the republic as a form of government, the respect for autonomies under public law, also the freedom of religion, also the exercising lawful authority, the parliamentarism, the equality of rights, the acknowledging of judicial power, and also, let's say a final example, the protection of nationalities living with us. These are, among others, the achievements of our historical constitution and the constitution of Hungary, the fundamental law, and actually the entire Hungarian legal system is based upon it. The protection of constitutional identity, according to the Hungarian constitution's establishment, it may be raised in cases having an influence on the living conditions of individuals, and in particular, their privacy protected by fundamental rights. Also, on their personal and social security, and on their decision-making responsibility, and when Hungary's linguistic, historical, and cultural traditions are affected. So all in all, the approach of the Hungarian Constitutional Court in regard to identity control is to somewhat different, and it is more enshrined to the Hungarian historic constitutional traditions, and also to some extent more clear-cut related to national identity and democratic legal traditions. In the light of this decision of the Hungarian Constitutional Court, the fundamental law of Hungary has also been adopted. And according to this change, it is very clear-cutly said that the territorial unity, population, and the form of government and state structure, it is something which is inherent in the Hungarian constitutional identity. And I think with this regard, we are arriving back to the basic point that defending the constitutional identity is a task for the Hungarian Constitutional Court, because it is the most important legal body in the Hungarian legal system, which is allowed to deal with the international legal statehood of Hungary. As we know, from the decision of Max Huber in the Las Palmas arbitration that the territorial union, the population, and the stable government upon it are the three main components of the statehood. And it is exclusively the power of the Constitutional Court to establish if and potentially an European Union secondary norm would be in breach of these basic funding structures of the Hungarian statehood. What would happen then? Of course, it would mean that the Hungarian Constitutional Court would prescribe that these norms should not be or could not be executed by Hungarian state organs. Of course, the quota decision of the Hungarian Constitutional Court remained on a very theoretical basis. It highlighted its main points regarding the way how, in principle, the Hungarian Constitutional Court should and could protect the Hungarian statehood and the Hungarian constitutional identity in relation to any potential dangers. Nevertheless, it has been also created in a way so it should stay as a weapon in the drawer. We've made our position very firmly, but at the same time, we are very open for a very constructive, very friendly, and a very open dialogue with all the European partners for a better European future. Thank you very much for your attention.